Let's just go across to Lyal S. Sunga, who's been looking very carefully at what's happened. Mr. Sunga, could you perhaps interpret this particular statement? The court has declared a continued stay of execution which constitutes an indispensable condition for the effective review and reconsideration of the conviction and sentence of Kulbhushan Jadhav. Is this not a very strong statement and an indicator of the path that the legal process in Pakistan needs to take? This seems to indicate to me that there is something wrong profoundly which has taken place, and therefore Pakistan is under obligations now to rectify this. That's my reading. Is that yours as well, sir?
Yes, but I think it's even more simple than that. It's that, in fact, if the court and the system in Pakistan were allowed to go, obviously, and execute judgment, which is the death penalty, the case would be rendered moot. So it's a very basic, simple statement in that sense. You can't have effective review and reconsideration that makes any sense if the death penalty went ahead, and that was his sentence. So, more broadly, we're speaking about, fairness. And I just want to highlight something else very quickly, if I may. And that is that there may be a distinction between effective review, which could be a kind of appeal in this case, and reconsideration, which might hint at a retrial, possible retrial. Because the issue is that if the original trial, if Jadhav was not allowed to have consular access, and we should highlight one important point, and that is that if he was not able to mount an adequate legal defense, right to defense is part of Article 14 of the International Covenant on Civil and Political Rights, to which India and Pakistan are both parties.
Yes.
And without that consular access, then that trial, the first trial, is tainted, and for international human rights law to be satisfied, it should be a fresh trial, and hopefully within a civilian context, but that there's some scope for debate there.
So, Mr. Sunga, is there a possibility, depending obviously on what a Pakistani court, either military or hopefully a civilian court, actually decides, that India can once again appeal to the International Court of Justice should it be required? Does this process potentially continue?
Well, let's be very clear about this, and that is that the International Court of Justice is not a court of appeal. It is not an international criminal court. It is not there to decide the merits of the case ab initio, from the ground up. It's there to see whether there's been a breach or not of international law, and in this case, it's very clear that there was, and I'm not surprised by the ruling, and that's the denial of consular access and also denial of right to fair trial, and so that's what the ICJ can rule on, and that's what it's competent to rule on.
All right. Lots of points there, Mr. Sunga. I appreciate that.